I want to bring on our next speaker, if she is available, to talk about estate and financial planning. And so just to give you some background, no matter where you are in your planning journey, having knowledge of saving and planning and the available resources is crucial. The goal of special needs planning at the heart of it is to maximize and supplement government resources that you or your child may need or be entitled to in the future or may receive during their lifetime. And so, see on here, waiting for Heidi to join us via the camera. And just a reminder, I know many of you have questions as it relates to special needs trust and guardianship and all the fun stuff of planning. But I see Heidi now. Hi, Heidi. Good morning.
Good morning. How are you?
I'm fabulous. How are you today?
I'm great.
Awesome. Well, it is such a pleasure to have board certified elder law attorney Heidi Friedman here to discuss everything about estate and financial planning with the remaining time we have. But before she gets started in her presentation, we're going to run just a quick poll to see how many of individuals have even started their estate planning. So for those on Facebook, you won't be able to participate in the poll, but we want to allow everybody just a quick yes or no if they have started their estate planning.
Oh,
We'll give everybody, no, we're going to give everybody a few minutes. So 40% said yes, 60% said no. So Heidi, you have your work cut out to convince everybody on why it is so essential to start your estate planning. But with that, I'm going to hand the reins over to you.
All right, except for I have to find my PowerPoint. So give me 1 second. I'm so sorry. I don't know what to do with it.
That is all good. That's the great thing about having this recorded. You know, people can skip all the chit chat and go straight to the meat of things.
Yeah, I'm not sure. Oh, here it is. I'm sorry. I have found it. All right, let me get it started. So I can share.
Yep, you should be able to share your screen. And once again, just in case you're not able to capture all the information, we will be sending out the handouts and presentations today and key takeaways documents to everybody who's registered. So just in case you do miss it, we'll have it for you.
Okay, so let me get started. First of all, let me just, we're going to be talking, I'm so excited to talk about protecting your family and having peace of mind, estate planning for the families with special needs. Let me hope I can get this. So just a little bit about me, just so you know who I am and can understand why I can actually talk about this. So I am an attorney. I've been an attorney since 1994. I used to practice in a mid-sized firm and lobbied in Tallahassee. I represented a large university at that time. I did a lot of student and employment discrimination cases. So I was always kind of involved in this area, but not in the way that I am now. In 2007, I became an elder law attorney and I was board certified in 2016, which means that actually there's only 118 other board certified elder law attorneys in the entire state of Florida. So I'm one of 117 other attorneys that say I specialize in this area of law. And a lot of people say, well, you're in elder law, so what does that have to do with special needs? But it's really interesting because they really do cross over with regards to government benefits and estate planning and things of that nature, asset protection. I'm a director of certain different organizations and things of that nature. And I'm a member of the advisory council of Broward Age and Disability Resource Center. My most proud moment is the mother of 2 boys. One is 22 and my youngest one is turning 18 today. So I have no babies. Oh, am I talking too fast? I'm sorry. And I'm the owner of the Friedman Elder Law Department. So how did I even get into this? This is my baby. This is on January 14, 2000. My life did change forever. My son, Jeremy, came into the world, and this is actually what he looked like. I had no experience at all with any kind of special needs or anything like that. So he really did throw me into this world. But I like to show people of him now because, every time people see that picture, they get very like, oh my gosh. And this is him right now, and he's doing amazing. As a matter of fact, he is graduating from the Dan Marino Center on Friday, next week, and we're very proud of him. And that's my other little one. So let's get into this. What are the major concerns for parents with children with special needs? Let's be real, it's the future. If any of you have, all of you who have children with special needs, we're always so concerned about the future. And like it or not, our children are going to grow up. Whether we want to or not, I've tried to keep mine in a bottle, but it has not worked. So they are growing up. So we want to make sure that we've prepared for their future. So how do we do that? We do that by doing the proper type of planning. And when we talk about what are the benefits of planning, because a lot of people don't want to think about the future. I know when Jeremy was little, I really didn't want to go there. But before I knew it, I needed to be there. So it's really important to really start thinking about this. And the benefits of planning are really to provide financial security, leverage, public benefits, Medicaid, SSI. Select a proper team to provide life management, plan for appropriate housing. So my son, who's 22 years old, housing is an issue for a lot of our young adults with special needs. Definitely provide an ongoing system for advocacy, making sure that his care is going to be taken care of in the future. Coordinating, family events and making sure that he's able to participate in that. Protecting them from any kind of predators. I can tell you that we've already experienced that in Jeremy's world, as I'm sure many parents have, especially with social media and Facebook and all of those other kinds of things. We want to make sure our children are protected, and also protecting assets for our other family, our other heirs. So when you're talking about planning, there are really 5 key components to consider: government benefits, incapacity planning, estate planning, a plan of care, and funding. How do you fund for their future?
Excuse me, this is the interpreter. Can you please slow down a little bit?
Yes, I'm sorry.
Thank you so much.
I know I'm a fast talker, so I will slow down. So let's talk about the government benefits. When we talk about government benefits, there are 3 different types of government benefits. You have your needs-based public benefits. And what does that mean? That means that you have to meet their requirements, their financial requirements. You then have your entitlement public benefits. That I am entitled to this because I have worked or I have paid into the system. And then you have your other programs. There are other actual programs out there. And one of them is the Section 8 housing, which I'm really not going to get into, but I like to put it out there. And then there's SNAP benefits. SNAP is it actually used to be called the food stamps assistance. And for individuals who are on SSI, it's actually SunCap. So there is food assistance out there as well. When you're talking about SSI, a lot of people get SSI and SSDI confused. And I try to explain that there's basically a spectrum. So SSI is on one end, SSA, your typical Social Security, is on the other end, and then you got SSDI in the middle. SSI is for children or young adults like my child who is he actually hasn't worked. He receives a certain amount of money. He has to be, when I say needs-based, he has to meet the requirements, and I'm going to go into that in a little bit more detail. But once you are entitled to SSI, it comes with Medicaid insurance. Then if you paid in the system and you've worked enough quarters and you've worked your whole life and you've paid into the Social Security system at the age of 65, and now I think it's 66 and a half, you're entitled to Social Security. Social Security comes with Medicare insurance. Where SSDI comes in is that SSDI comes in is if you've worked in the system, you've paid into the system, but you become disabled for some reason, whether it's a car accident, an illness, or something, and you're no longer gainfully employed, you are now entitled to get your basically your Social Security early if you can prove that you are disabled and no longer gainfully employed. After 2 years of being on SSDI, you are then entitled to Medicare insurance. So those are the three different types, or the three different types of Social Security. So what does SSI provide? SSI provides a monthly cash assistance to the aged and disabled or blind individuals with limited income and resources. It is a means test. Currently, right now, in order to qualify for SSI, an individual can have no more than $2,000 worth of assets in their name. So it's definitely a means test, and it's an income test. Like I said, it automatically comes with Medicaid insurance. Now, I'd like to just stop here for a second and explain Medicaid is a huge umbrella of different services. There are, like I said, the Medicaid insurance that comes with SSI, but then you have food stamps, housing. We also, when we're working with the senior population or the disabled population that needs long-term care, there are 2 different long-term care programs that help pay for long-term care, whether somebody's living at home, in an assisted living facility, or even in a skilled nursing facility. So those are all programs that you can qualify for or not qualify for. And all of them, all of Medicaid programs have some sort of means test. So what is the eligibility requirements for SSI? Like I said, the person needs to actually be considered disabled, physically or mentally, or they need to be over the age of 65, but they haven't worked in the system. They haven't been able to work. So they're entitled to SSI. You have to meet your resource test and your income test. The resource test is that an individual can have no more than $2,000 worth of assets in their name, $3,000 for an eligible couple. And what is not counted is a home, automobile, furniture, clothing, or personal care, burial plots that are considered irrevocable. In addition, you have to meet the income. And this is where some families get into trouble, because they provide what we call in-kind support and maintenance. In-kind support and maintenance, when you're talking about SSI, is anytime that you're providing somebody with special needs who's on SSI, if you're providing them shelter or food, that is considered in-kind support and maintenance, and will reduce the amount of money that somebody receives from SSI. In addition, if they are living in the home and they are married, or they're a child, or you're able to deem somebody else's income, mostly kids under the age of 18 have their parents' income deemed onto them, so that's why they don't qualify for SSI. That also will reduce benefits dollar for dollar. And then there's also, if they start to earn money after $20, there's a whole formula that's out there that if you're earning money, you may also lose some of your SSI. Why do we always strongly recommend that our clients apply for SSI at the age of 18? Well, first of all, they are now adults, whether we like it or not. They might not be emotionally or mentally considered adults, but they are considered adults. And at that point, your income as a parent is no longer considered in determining your child's eligibility. Right now, today in 2022, the SSI monthly benefit is $841 a month. Now, how they expect people to live, to food and shelter on $841 a month, I don't know, but that's the amount of money that is given right now under SSI. And as long as an individual is receiving at least $1 of SSI, they are entitled to Medicaid insurance. Now, like I said, some pitfalls for SSI benefits, and I've seen a lot of clients who have done this, where they go and after their child is determined, yes, you are qualified for SSI, they explain that their child lives with them and that they are providing them food and shelter. Well, as soon as that happens, then that $800 gets cut by a third because that is considered in-kind support and maintenance. So we really want your child to be paying his fair share of rent and food in order to be able to get the full amount of benefits. So we always suggest that you enter into a rental agreement with your child using fair market value for renting a room in your area. And then when they do get their SSI, they actually pay you. So they need to pay you in order to make sure that they get that full amount. Now, obviously, once the money's in your name, you can do what you want with it, but give them food or shelter. So you want to make sure that if you're paying for their clothing or you're paying for their gas or their car or whatever, all of that can be done with the money that they're paying you. But again, if you don't enter into that rental agreement and you go in there and you say that you're providing your child with room and shelter, with room and shelter and food, you will see that their benefits do get cut by a third. So before we really get into the actual estate planning that we're going to talk about, like the special needs trust and everything, the other piece of this is the incapacity documents or guardianship. Once your child reaches the age of 18, like I said, he is now considered a legal adult regardless of mental abilities. So you may have a child that maybe functions on a 5th or 6th grade level, but he's 18 years old. So in the eyes of the law, he is actually an adult. And any decisions that he makes at that time are done just like as if you and I have done it. So if they enter into a contract or they get online and something happens, they are doing it as an adult. So you always have two options. Basically, what you want to do when you're talking about making sure that you're going to be able to act for your child is you want to use the least restrictive means possible. The least restrictive means possible is setting them up with a durable power of attorney and a healthcare surrogate. Now, I always recommend that anybody over the age of 18 have at least a durable power of attorney. And why is that? Because even if you're married, even if you're that person's parent or child, if there's assets or anything in somebody's name alone, regardless, again, if you're married to them or you're their parent or you're their child, you cannot act for them with regards to that particular asset. So it's really important that everybody who's over the age of 18 have a proper durable power of attorney in the state of Florida. I'm going to throw out a caveat here. I have many, many, many clients who contact me, who send me a durable power of attorney that's been done by either they've pulled it up on the computer, online, they've talked to maybe an attorney that doesn't do this area of law or a paralegal. And unfortunately, the durable power of attorney is not done correctly or it doesn't have all the pieces in it. Florida statutes are very specific on what you need to have in a durable power of attorney. So it's really important that this is not the area that you cheap out on, that you really hire an attorney that knows exactly what they're doing and what needs to be in that durable power of attorney. Because if you have a bad durable power of attorney, which does happen, and the principal or the individual who is signing the power of attorney becomes incapacitated, then you have no choice but to go to guardianship if your durable power of attorney is not set up right. And guardianship can be a very long and tedious and expensive process. So it's like the same, with that old saying, a penny earned is a dollar saved, or penny saved, whatever it is. We want to make sure that this is the time that you're really using an attorney that knows what they're doing. So in a power of attorney, the principal, that's the person who's actually going to sign the document, has capacity to understand the document and what it means. So if you have a young adult with special needs who can understand that, hey, if I sign this, my mom and dad or whoever I have named as the agent can still act for me with regards to my property or anything like that, they can sign a durable power of attorney. It also, though, still allows that principal to make their own decisions. So that's one thing you have to be careful of. Again, if you have a child or a young adult or somebody in your life that you feel they might not make the best decisions, then maybe the durable power of attorney is not the way to go, because they do not lose their right to act for themselves. The durable power of attorney is revocable at any time, as long as the principal has capacity, and it does not require anything with the court. As soon as it's signed and signed properly before two witnesses and a notary, and everything in there that you need to have in there is done, then that's all you need in order to be able to act on behalf of your principal or your child with special needs. So a durable power of attorney healthcare directives, really important if you have a child who has capacity, who can make decisions for themselves, but you don't want to remove all of their rights, right? You want to be able to do the least restrictive means possible to be able to help them. Now, if you have a child that does need more assistance or more help, you don't have to go through the full-blown guardianship process. The full-blown guardianship process requires you to file a petition, requires you to file an application for guardianship. But right after that, it also requires the court to determine that that individual is no longer capacitated. That's the full-blown guardianship. They actually send out a panel of 3 members. They go out, they do an assessment of the individual. They make a report whether or not that person is capacitated or not, and then they come back to the court. What we have done, or what Florida has done, is they've also allowed what we call the guardian advocacy. This is really for parents who have children or young adults with special needs. It does require the court to appoint the guardian. It still requires some filing of reports and court oversight. The individual needs to have a developmental disability. But what doesn't happen anymore with the guardian advocacy is that nobody goes out and determines your child as quote unquote incapacitated. And the difference between the two guardianships is, if you're going to do a typical guardianship, you have to have an attorney. With a guardian advocacy, actually, you don't even have to have an attorney to go forward. But again, if you have a child that can make decisions and is capable, and you just really want to be able to act for them or step in for them or help them make those decisions, durable power of attorney works just as well. So now let's get into the actual estate planning. I strongly recommend parents, even if you don't have children with special needs, but anybody who has a parent with children or anything, that you have the right estate plan for you. Now, at my office, we do different kinds of estate planning. We do estate planning for the special needs, but we also do estate planning for the 65 and older population, because the estate planning for the 65 and older population is a much different focused estate plan. That estate plan, we want to try to do asset protection to help somebody who may need long-term care in the future protect some of their assets. What we're talking about today is actually the estate planning for families with special needs children. And those families really need to take the time to make sure that you're with a proper a lawyer who can provide the proper type of estate planning, because your estate planning can literally make or break whether or not your child is entitled to government benefits in the future. So what do you need in your estate planning? A will. Many people come to me and say, I have a will. Well, just to let you know, where there's a will, there's a probate. So if all you have is a will, then your family, or when you die, your family or your beneficiaries will have to go through probate. The only difference between dying with just a will and dying with absolutely no documents is that the will tells the court where you want your assets to go upon your death. But understand, you do not avoid probate. Then you may need a revocable trust, and we always strongly recommend a revocable trust. I get a lot of people who say, I don't really have that big of an estate, why do I need a trust? Well, a trust is there to help you a couple of ways. One, during lifetime, so you can put into the trust what you want to have happen during your lifetime with your assets. Initially, you may be the trustee, but what happens if you become incapacitated? Who should step in? What those assets should be used for? Who should be the beneficiary? And then on top of it, what happens to those assets when you die? And that's when the special needs trust can come in. What happens to your assets when you die to make sure that your child is still protected and still can receive whatever government benefits that they're entitled to receive? When we're talking about special needs trust, there are three different kinds of special needs trusts. There is a third-party special needs trust. This is actually the special needs trust that we use when we're doing estate planning with parents who have young adults or children with special needs. A third-party special needs trust is a trust where anybody other than the beneficiary, which is the person with special needs, anybody else's money can be put into that trust. It can be established pretty much by anybody, again, except for the beneficiary. So we have grandparents who have created special needs trust for their grandchildren. We may even have an aunt or uncle that has created a special needs trust for a niece or nephew. But for the most part, we get parents who are creating the special needs trust for their child. Now, when you're talking about creating a special needs trust, there are two options to do it. One is that you embed it in your revocable trust. Basically, what that means is that you have a revocable trust that says, upon my death, this special needs trust will pop out and will be created there for my child at that time. And I'm going to tell you how much money I want to be put into that special needs trust at that time. The other way to do it, and what we strongly recommend, is that you do a third-party special needs trust completely on its own. That is a revocable trust during the parent's lifetime or whoever's creating it, which is, we call that person the settlor, so that anybody else can put money into that special needs trust. So for example, I have a special needs trust for Jeremy. So when Jeremy's grandparents die, God forbid, and hopefully that's a while away, they can put any money that they want to give to Jeremy into that special needs trust. And I don't have to die first for that to happen. So that's a standalone special needs trust that we recommend that you have, especially if you have other people who are going to want to bequeath money to your child or give money to your child while you're still alive. And then again, upon death of your child with special needs, that money can then be determined. You can then determine where that money should go. So should it go to your other children? Should it go to a charity or whatnot? So that's your third-party special needs trust. The great thing with the third-party special needs trust is that there's no payback to the state of Florida for any of the Medicaid benefits that they're paying out for your child. And it's unlimited. It can have as much money in there as possible. It has also a little bit, there's a little bit more flexibility than some of the other trusts. The next trust that we talk about is a D4A trust. A D4A trust, or also known as a first party trust, is a trust that is created specifically by the beneficiary. This usually happens if, there was a car accident or something happens and now they have a settlement, or they have they're receiving any kind of settlement or any kind of money. Or if, let's say, your family member left money to your child, or they didn't use your third-party special needs trust, and now your child has money in his or her name, and that money is going to kick them off of benefits. It's a first-party special needs trust. It's created by the beneficiary themselves. They do have to be under the age of 65. It can be created or signed. So let's say you have a child who, listen, my child really can't create their own special needs trust. You can create them, a court can create them, a guardian. The main thing about the first party special needs trust and why it's not as great as a third party special needs trust, if you can prepare, is that there is a payback to the state of Florida upon the death of the beneficiary, dollar for what it's paid out for that beneficiary under Medicaid. So there's definitely a payback at that point. Sorry. Then also the final one is a pooled trust. A pooled trust is really used a lot more when we have individuals who are over the age of 65 because they can't do a first party special needs trust. It is run by a not-for-profit organization. It can again be established by anybody. You can put in the disabled money, the disabled individual's money themselves, their money goes into a pooled trust. basically you sign an individual jointer account. It all gets pooled. The not-for-profit does all the investments. They act as the trustee. There are fees, annual fees, and each pool, there's several pooled trusts in the state of Florida, so they all have different fee structures. And again, just like with the first party special needs trust, it does have a payback at the end, but there's a choice. At the end, you can either have them pay back the state of Florida dollar for dollar, and then whatever is remaining can go to your remaining beneficiaries, or you can have them have the not-for-profit keep what's remaining in the trust for the other beneficiaries that are in the pool trust. So there's an option there. So what is the third-party special needs requirements? Again, just to let you know, third-party special needs trust is a trust established by someone other than the beneficiary as the grantor. Now, the grantor is the person who's establishing the trust. That's either whether it's a revocable trust, a special needs trust. However, in the state of Florida, we call the grantor the settler. Don't know why, but that's what we call them. And that is the person who's going to create the trust and the person who's going to put the money, or the corpus is what we call it, into the trust. And again, as a parent, if you're creating a third-party special needs trust, anybody but the beneficiary of that trust can put money into that trust. Once again, the big benefit of a third-party special needs trust: no Medicaid payback. So upon the death of the beneficiary, you can absolutely take whatever money is remaining in there and either bequeath it to your other children, bequeath it to a charity, bequeath it to whoever you want. There's no payback. First party special needs trust, individuals' own funds are placed in that. It's their trust. There is a payback. And again, it's the same as having a pool trust, because again, there's a payback under that. And this is just talking about the pool trust. Pool trust is irrevocable. It's established by a not-for-profit. Each person has their own separate account, but it's pooled for purposes of investment and management. When you're talking about doing a special needs trust, there are certain questions that you need to ask yourself before you actually start creating it. One is, what is the purpose of the special needs trust? If your person or your beneficiary has worked and they're now receiving SSDI, SSDI is not a means test, right? You can have as much money as you want, as long as you're not earning income, you're not gainfully employed. You can have as much money as you want, as long as you've paid into the system, you're determined disabled, and now you can receive SSDI. There's no reason for a special needs trust if you have SSDI. So the purpose of a special needs trust is for individuals with special needs who are going to receive SSI. Now, if your SSDI person also needs Medicaid, well, then you would also want to have a special needs trust, because Medicaid, again, is a means-based program. So again, you cannot have more than $2,000 worth of assets in your name. So if you have money in a special needs trust, a properly set up one, then any money in that trust is not counted as part of that $2,000 resource allowance. Who will serve as the trustee? This is always a very big question for family members. And most of the time, what family members will do is they'll say, oh, I'm going to have their sibling serve. I'm going to have, my other child serve as the trustee. And while that is okay, we sometimes try to counsel people out of that and say, you might be better off getting a professional in there for a couple of reasons. One, because if your sibling or the individual that you name as a trustee really doesn't know how to handle a special needs trust, and why would they? They don't have education on this, not something that you automatically learn. If they mess up the trust, for example, if they start to give money directly to the beneficiary in a third-party special needs trust, it'll mess up the trust, then that trust won't serve its purpose. Second, I have a child myself. I have a younger child, and I have Jeremy. And I don't want to put that onus on my younger child that he has to be there, the one that writes the check for Jeremy, takes care of all of his budget, I want to make sure that there is a trustee there that does all of that, but that my younger son is still involved by making sure that he's either acts as Jeremy's advocate or on his care management team. So it's really important to really think about who would serve as the trustee and not just jump to the conclusion that, oh, I'll have my other child do it. What assets should fund the trust upon death? And I'm going to get a little bit into that, but I will tell you that a lot of people automatically think I'm going to put life insurance into the special needs trust, and I have this big IRA that I'm going to give to my other child. Well, in actuality, that's not always the best situation. And why is that? Because life insurance, when you bequeath life insurance, it comes out tax-free. So you're putting tax-free money into your special needs trust. If you have an IRA and you bequeath that into your special needs trust, we can stretch out the tax consequence of that IRA. So really and truly, it should be opposite. You should actually put your IRA into a qualified special needs trust, and your life insurance policy should go to your typical child. But I'm not a financial planner, but you really do want to determine what assets should fund the trust upon death. Should the trust pay for housing for my child? Again, as I mentioned at the very beginning, if your child or anybody is paying for housing for your child, their SSI is going to get cut by a third. Well, sometimes cutting it by a third is okay if I'm going to get them a better house under the trust. So again, that's always a decision to talk about and decide as you're going through the process. And who should serve as the trust protector advocate or on a care committee? And that's what I was talking about, maybe having the sibling act in that role so that they can advocate on behalf of their brother or their sister, but they're not actually the trustees, the one writing the checks and making those decisions and having that fiduciary duty. Here's what I was talking about with the IRA and the Secure Act. I don't know if any of you know, or maybe a lot of you know that, a few years ago during the Trump administration, the Secure Act came out and said that any IRAs that are inherited by people that are not considered a proper beneficiary, which a proper beneficiary is a spouse or a minor child or a child with special need or an individual with special needs, that any IRA must be paid out within a period of 10 years. That means that if you have an IRA, that your beneficiaries, if they're not one of those three people, would have to have that IRA paid out within 10 years, and the taxes have to be paid out within 10 years. However, if you are an eligible beneficiary, which if you have a child with special needs and you have a proper special needs trust set up for them, then the IRA payment can be stretched out for as long as the child's life expectancy. So you can stretch it out significantly. And not only that, the qualified special needs trust gets a first tax exemption for the first $4,100 that comes out as income. So there's a lot of tax benefits that you putting your IRA into a qualified special needs trust has, and the Secure Act made it even more beneficial for us to put our IRAs into our qualified special needs trust for our children with special needs. The other thing I like to talk about when I'm talking about planning is the ABLE account. And I'm not going to really go into it because obviously that's a big part of this whole thing, but many people ask me, can I have a special needs trust and an ABLE account for my child? And the answer is absolutely yes. And as a matter of fact, in all of our special needs trust, we actually allow the trustee to be able to open an ABLE account because they work very well together. The ABLE account allows that individual with special needs to have more control of their money. The money can be used for things that they may not be able to be used for under the special needs trust. So having them both work in conjunction is really the best planning for your child. All right, let's get into the plan of care. So in addition to making sure they have the incapacity documents and making sure you have the right estate planning with a proper special needs trust so that they can continue to qualify for government benefits, you want to make sure that you have a plan of care or a letter of intent. Because again, remember, our children are going to grow up And we have to really think about it, about what's going to happen to them when we are no longer here. Who's going to be able to talk for them? Who's going to tell somebody who's taking care of them? What is their diet? What do they like to do? What kind of social activities do they like to do? What kind of behaviors do they have to be aware of? So a plan of care is a very big part of your entire estate plan. You want to make sure that you have one as well, so that whoever steps into your shoes when you die, to make sure that your child or your young adult or your person with special needs is taken care of, you want to make sure that it's written somewhere that somebody can look at. Who are their doctors? What medicines are they on? All of that stuff needs to be written down somewhere. And then let's talk about funding you and your child. Again, you want to make sure that there's money there, whether it's using life insurance policies, IRAs. You want to make sure that there's diversification. You have the right financial planner out there that is doing what they need to be doing, because at the end of the day, the government benefits are not going to pay for everything. So you need to really be aware of, okay, when I'm gone and I'm no longer able to pay for things for my child, who will be able to pay for those things? So we want to make sure that you're talking to a proper financial planner. I always say, I build the house, the financial planners build the furniture. You want to make sure that you fill the house with the right furniture in the right place, so that your child has a place to go, and that you don't have to worry what's going to happen as I age and I'm no longer able to take care of my child. When you're talking about doing financial planning and you're thinking about it, you want to think about some questions, right? Will your child be able to work? Will they be able to live on their own? Have you set up that ABLE account? These are all things that you do want to take into consideration when you're talking about what funds should I put into my special needs trust, or what funds do I give to my one child versus the other child? If you have more than one child, to make sure that your child with special needs is properly taken care of. What if you're not around? These are some questions that you should be asking yourself. I know it's a hard question. Nobody wants to think about it. Nobody wants to think about our children becoming adults. And we certainly don't want to think about what's going to happen if we're not around. But these are some questions that you really should be asking yourself. Who will take care of your child? Is there proper life insurance so that there's money there for them? Do you have a disability insurance? What happens if you become disabled? Who's going to take care of them? Where do your retirement accounts go? Should they go into the qualified special needs trust to avoid taxation, stretch out the payment of the IRA? The Secure Act allowing those dollars to be stretched out a lot more than 10 years. So these are some things that you really want to make sure that you're thinking about for the future. One thing I can't stress enough, people ask me all the time, when should I start doing this? The answer is now. If nothing, this pandemic and COVID and everything has shown us that none of us are here forever, and that we are not guaranteed any type of future or any type of anything. So you want to make sure that you have peace of mind by setting up a proper estate plan, setting up the proper planning for your child, so that in the event that you're not able to take care of him or her anymore, or you're no longer here, that you have that peace of mind that they are being taken care of, that you have the people in place for them, that you have the dollars in place for them, that you have not cut off their government benefits by setting things up inappropriately, that you're able to make choices for them and decisions for them. So let's sum it all up. What can you do for your child? Establish a plan. I can't stress that enough. Establish a plan, talk to somebody, make sure you have the right plan. At age 18, apply for SSI. I know a lot of people that come to me that have young adults with special needs. They're 22, 23, 24. And the first question I ask is, have you done SSI for them? And no. Why should I? Absolutely. Get them on SSI. Do the least if you're having them live with you. Get them qualified for the Medicaid insurance. Make sure that they have these government benefits in place now while you can. Set up the proper estate plan. What's going to happen when you die? You want to make sure that everybody's set up. What's going to happen if your parents die and they want to leave money to your child? You don't want to kick them off of any kind of government benefits. Set up the right estate plan. Set up an ABLE account. We set up an ABLE account initially for Jeremy with $25. Now Jeremy works, we put more money in there. So set up an ABLE account. It's a great way. It's like a 529 account. It's a great way for them to have some control over their dollars, great way to have more flexibility over their dollars, and it's a great way for them to save dollars. Plan for unforeseen events with a plan of care. Again, write it down. Nobody's going to be able to know what's in your head unless you write it down. Don't expect that their siblings are going to know everything, or that an aunt or an uncle or a grandparent. You need to write it down. And definitely think about the future, because guess what? Like it or not, it's coming. Don't let this happen to you. Don't put your head in the sand and think, I don't want to think about my future with my child with special needs. I know we all go through that. I went through it myself. I don't want to think about it. But guess what? He's 22. Here it is. My future is here with him. And it happened before I could even blink. And as Picasso said, only put off tomorrow what you're willing to die having left undone. So thank you very much. And that is my presentation.
Wow, Heidi, what a wealth of information. I could tell you're passionate and excited, and you're like me, who could just talk for hours and really fast.
Sorry. I'm sorry, you guys. I'm sorry. I tried to slow down.
I'm in the same boat. I got dinged a few times as well. So, but thank you all. I think it is important for our interpreters. So I'm going to extend our time, because I know we have tons of good questions, because I know this is one of our most discussed topics, not only just part of planning and ABLE accounts and special needs trust, but we'll just tackle a few of these. One of the questions is there Medicaid or Medicare liens on an account if a person passes away? Medicare.
Is there what?
Any type of liens on a person's account, an ABLE account, if for Medicare?
For Medicare? No.
Yes,
So
that's
Medicare is insurance. It's like any other kind of insurance that you have. So there's no Medicare liens. Now there are, if you're in a car accident and you use Medicare, and then they're doing settlements and judgments and things like that, there are all Medicare liens in that area. But not as far as when somebody dies, like a payback to the state of Florida for Medicaid. No.
okay. And you might be able to answer this better than I, because one of the questions that for ABLE accounts often receive is what happens when the beneficiary passes away. And I know, unfortunately, we've had several individuals here in the state of Florida that have had ABLE accounts and passed away. And we usually send those funds to the benefit of their estate. This may be more estate planning probate, but the question we often get is, are those funds taxed? The earnings portion of the ABLE account funds taxed? How do I plan for my ABLE account if I'm the beneficiary of one? Can you answer any of those types of questions?
So I guess the question is, are you taxed upon death? Is that
Yeah, so leftover ABLE funds, let's say all outstanding qualified disability expenses are paid, and then they end up going to the estate of the beneficiary.
So I can't tell you whether or not, and maybe you know better than I do, John, and whether or not because it's coming out like a 529, if there's a tax that way. But as far as inheritance tax, right now, I'm going to tell you that all of us would love to have to pay taxes on inheritance, right? If we get an inheritance. And the reason why is because, especially in the state of Florida, there is a federal tax exemption of $11.45 million for each one of us. And if you're a married couple, there is an exemption it's called portability that for twice that. And what does that mean? That basically means that during our lifetime, we are able to give away or bequeath $11.45 million without the beneficiary having to pay one dime of tax on it. So a lot of people get this very confused, right? They'll call me up and say, but I want to be able to give $15,000. I guess I have to gift away $15,000 every year because it's not taxable. So I get that a lot. And what people don't understand is, again, I try to say, like, think about it like you have like this kind of box or sandbox that has $11.45 million in it. And when you bequeath when you give away or bequeath anything over $15,000, you have to take it out of this box, out of the sandbox. If I give you, $50,000, John, I have to now take it out of my $11.45 million exemption. However, if I give you $15,000 every year, it never touches my exemption. So when you're talking about those $15,000 gifts that people, I get this all the time. Oh, but I'm going to give away $15,000. I always say to them, wow, you must have a lot of money, because that's really truly the only people that need to really enter into those kind of gifting programs. Like if you're like Bill Gates, right? So Bill Gates should be giving $15,000 away to a bunch of people. I'll stand in line for it, so that he can reduce whatever taxes his beneficiaries will have to receive upon his death, because obviously he's got more than $11.45 million in between him and his wife. They have more than 22, 23. So as far as taxes for inheritance purposes, no, you're never going to have that much money in an ABLE account. Now, that's the amount right now, the $11.45 million, and that went into place during Trump's administration. That sunsets in 2025. What's going to happen after 2025? I don't know. But even if they reduce it down to where it was before Trump, it was still $5.4 million per person that you could bequeath or give away.
That's good information. I know there's several other questions still waiting to be answered when it comes to ABLE accounts. So a question I got here, somebody's moving into the state of Florida. They have a special needs trust, created documentation from a different state. Do they have to get that all updated or renewed, or, special needs trust dependent on each state?
Right. So yes, we always recommend that if you're moving into our state or any state, that you contact an attorney in that state and update your documents, especially if you're coming here to, like we have snowbirds that come back and forth. So they have to make a decision. Are you going to be a Florida resident or wherever you are? But we always recommend that you at least have it looked at by a Florida attorney, and that if there's any changes that need to be made within the state, because understand special needs trusts are, while they're federal, there's these federal guidelines, there's also state guidelines, and Medicaid is a state-run program, even though it's federally funded. So if you're moving into Florida and you have a special needs trust and you have all of that, it's always a good idea to have a Florida attorney check it and make sure that it's tweaked if necessary for Florida law.
That's great. I know we're a little bit over time, so I wanted to just thank you, Heidi, so much for taking your time this morning, now afternoon, to talk about ABLE account, special needs trust, just estate planning as a whole. I know it's a lot, and I love your words of wisdom. It's just getting started and doing it today and not putting it off. I know it's a hard thing, but it's so important. So thank you all so much. Thank you all for tuned in for the last 3 hours to talk about all things ABLE related. I know knowledge is power, and we appreciate each of you for taking the time to hopefully learn more, to get the resources. There's been questions on, will I get my certificate? And so we'll be messaging or sending that out to everybody who attended. And if you have specific questions still, please send us an email to info@ableunited.com, and we'll get to your answers as we can. But with that, I hope you all have the best rest of the day and a good weekend as well. Until we talk again, thanks.